Okay, so we are doing this review, and review we know that as a subject aforesaid person concerning himself aggrieved, who's the person, any person who is concerning himself aggrieved by a decree or order from which an appeal is allowed by this code, means which code they are talking about, criminal procedure code, for which no appeal has been preferred. So if there is no appeal, they may go for a review, and by decree or order from which no appeal is allowed by this code, means by this code if there is no appeal is allowed, then they can also go for review. And if by the decision on the reference from a court of a small causes may apply for review of judgment to the court which passed the decree or made the order, and the court may make such order thereon as it think fits. So for the small causes, from the references, we may apply for the review of the judgment of the court, and which passed means which court that have passed the decree. So here conditions is that discovery of new and important evidence. So any new and important evidence has discovered. Also there is a mistake or error apparent from record, means mistake and error has apparent from the records, and also any other sufficient reason. So for any other sufficient reason, we may go for the review. If any new and important evidence has occurred, we found a new evidence that could change the case, so for that thing we can go for a review. And also mistakes or error apparent from record, some mistakes and error that has been apparent from the records, and also if any sufficient reason we feel so, we can go for the review thing. So what are the review rules under this? So review has many rules. Like rule number 1, we have review proceedings are not by way of an appeal, have to be strictly confined to the scope, means if there is an appeal allowed, then there is no review. And also no application for review, however, shall be granted without previous notice to the opposite party to appear and oppose the application. Means here in this case, the other party has to have a proper notice, and to forward reason, means application for review we cannot grant without any previous notice to the opposite party, and to appear and oppose the application, means they have a right to appear and also oppose the application which we have made. So for that we need to give prior notice to the opposite party. Also, where the application for review is heard by more than one judge, if there is more than one judge is involved and court is equally divided, and like the earlier cases, there is a bench we talk about in a general sense, so the application shall be rejected. With this a majority, the decision shall be according to the opinion of the majority. So we cannot file review against a bench where the decision has been taken according to the majority. So an order for the court rejecting an application for the review shall be appealable, means we can if the court has rejected review application, so we can not appeal, okay, but an order granting the application may be objected to at once by an appeal from the order granting the application, or in any appeal from the decree or order finally passed or made in the suit. Also we have another rule, that is no application to review an order made on an application for a review, or a decree or order passed or made on a review that shall be ante, means no application for review an order made on an application for review or an order passed that has been already passed, means review order has already been passed and then again we were going for a review. So we cannot review, we cannot review so many times. So there are some secretarial standards, and it is related to Companies Act, and we need to go once with all such points. There like secretarial standard 1, that is meeting of the board of directors. What is the applicability of it? That every company is required to observe Secretarial Standard 1 except OPC and also the such class of company which are exempted by the central government through notification. So for OPC, it doesn't need to follow the secretarial standards, and also any other class of companies which central government has accepted through its official gazetted notification. So we have that is basically the section 8 companies they are talking about. So we have convening, that is subject to article of association of the company. Board meeting may be convened by any director, means as per the AOA of the company, board meeting may be convened by any of the director and also the company secretary, and if there is no company secretary, any person authorized by the board in his behalf on the requisite of directors. Requisite majority they are talking about, or requisite number that is required to hold a board meeting. So any director, it may be convened by any director and also the company secretary, and if there is no company secretary, any other authorized person, the board has been has authorized him on this thing, and on the requisition of a director, means director has requisite to him, and then he may go for board meeting to be get convened. Now we have a date, time, place, mode and serial number. We know that it is mandatory for every meeting to have a serial number for the ease of reference, and also now board of directors meeting can be convened even on Sunday, even on national holiday. Even a meeting of the BOD adjourned for want of quorum can be held on a national holiday. Means if any board of means if a meeting has been adjourned, then that can also be held in the national holiday. We know that why they have not put any restriction on that, because board meeting can be held at home, any place. So there are chances, like the private company, like husband and wife could be director, so they do not wait for the working day to get the meeting done. That could be on Sunday, that could be on at home. Okay, so there is a notice. However, there is no restriction on a company to hold its meeting through electronic mode. There is no such restriction. The company ensures presence of physical quorum during consideration of any of restricted items of business and comply with the applicable legal provisions. So basically, there is no such restriction on a company to hold its meeting through electronic mode. Company can hold that meeting to the electronic mode, and also the company needs to ensure the physical quorum has to present during the meeting. So any of the restricted item of the business, that is any of the restricted item has to, when they wants to do, and with the applicable legal provisions, means if there is any applicable legal provision that has to comply with. Now the director intending to participate through electronic mode, when the director is intending to participate through electronic mode, should communicate his intention to the chairman. They need to communicate their intention to the chairman or the company secretary of practice. He should give prior intimation to that effect sufficiently in advance so that the company is able to make suitable arrangement in this behalf. So if they want to convene their meeting through electronic mode, then they give this thing, and then they give advance notice so that a company should make suitable arrangement. Also there is an annexure that is illustrative list of items of business which shall not be passed by circulation and shall be placed before the board meeting of its board at its meeting. Now the general business items, that is noting minutes of the meetings of the audit committee. General business items are noting minutes of the meeting of audit committee, also other committees, also approving financial statements and the board report, considering the compliance certificate to ensure compliance with provisions of all applicable laws of the company, also specifying list of laws that are applicable specifically to the company, appointment of secretarial auditors and internal auditors, specific items that are borrowing money otherwise than by issue of debentures, investing the funds of the company, granting loans or giving guarantee to provide securities in respect of loans, and making political contributions. Now making calls on shareholders in respect of money and paid on their shares. Now approving remunerations to managing directors, whole-time directors, managers, Appointment for removal of the KMP, also appointment for the person as a managing director, manager in more than one company. So in case of a public company, the appointment of the directors and the casual vacancy subject to the provisions in articles of the company. So according to the sanction of the related parties transactions which are not in the ordinary course of the business, for which are not on arm length basis. So sale of subsidiaries, also the purchase and sale of material, tangible, intangible assets not in the ordinary course of the business, and also approve payments to the directors for the loss of office, and also items that are arising out of the separate meeting of the independent directors, if so decided by the independent directors. So what we have read here, there is some general items and there is some special items. So general items, we know that general items are like noting of the minutes of the meeting, and also the audit committee meetings, other meetings, or the other committee meetings. So basically all other committee meetings that are comes under the general business items. So approving financial statements, that are comes under the board report, so it is also like general item. Also when we are considering the compliance certificate to ensure that company is complying with the provisions of all law, so compliance certificate is also comes under the general business item. And like specific list of the applicable laws of the company, if there is any other law which is specifically on the company, then it also comes under the general business item. And like we have appointment of secretarial auditor and internal auditor, this also comes under the general business item. Specific, we have already gone through that, like investing the funds of the company, granting loan, political contribution, making calls to the shareholders, approving remuneration to the managing director, if managing director in more than one company, removal of the KMP, purchase of the material, tangible asset and intangible in the ordinary course of the business, sale of subsidiary. These are the items which are specific. So corporate actions, if we know that authorized buyback of securities, issue of securities including debentures whether in or outside India, also approving amalgamation, merger or reconstructions that are diversifying the business and also take over another company or acquiring control or substantial stake in another company. Also there are additional items, list of the items in case of listed companies. They are like noting minutes of board meetings of the unlisted subsidiary. This comes under the additional items. If we are noting the minute of the subsidiary, also the quarterly, half-yearly and annual financial results of the listed company, recruitment and remuneration of the senior officers just below the level of the POD, and also agreements by the company with existing share transfer agent, the new share transfer agent in the manner as specified by the board from the time to time. Now statements of significantly transactions and arrangements entered into by the unlisted subsidiary, and also approving the annual operating plans and budgets, capital budgets and any updates. So information on remuneration of KMP, show cause demand, also prosecution notices, penalty notices which are materially important and fatal or serious accident, dangerous occurrence, any material effluent or pollution problems. So we have drafting on agenda. So here is a topic, that is, if in the due course of the board meeting any agenda item that is containing a proposal is deferred for consideration to a subsequent meeting, then there is any change in the said proposal, so the note on agenda of new proposal should explain the modification in the proposal. Since the board was already provided with the agenda of the earlier meeting and has been informed of the earlier proposal. So what has happened in this case, that the drafting agenda, that is, if the during course of the board meeting any agenda item containing a proposal that is deferred for consideration, that we have been deferred, okay, we'll discuss it in another meeting, then what happened in the subsequent meeting, if and there is any change in the said proposal, if any change has been occurred, notes on agenda of the new proposal should be explained the modifications thereof, and also we need to provide it with the agenda of the earlier meeting that has been informed of the earlier proposal. Shorted notice or short notice and agenda, what we want to say here is that is to transact any business. If we want to transact urgent business, notice, agenda and notes on agenda may be given at shorter period of time stated above. So to transact urgent business, basically the notice, agenda and notes on agenda must be given at a shorter period than the stated above. So there is a time period that has been specified. So for the urgent business, we can give notice and agenda on a shorter duration basis. So, but if at least one independent director, if any, shall be present at the meeting. So we can go do so, but there is one independent director has to present at the meeting. So additional content in such shorter notice issued for conducting urgent businesses. So we have the fact that the meeting is being held at a shorter notice shall be stated in the notice. So we need to include the facts that why the meeting is being held at a shorter notice, and also holding a meeting at a shorter notice is deviating from the conventional practice. So hence this fact should be brought out in notice, convening the meeting as a good governance practice, and the reason for convening the meeting at short notice may also be stated in the notice. So the thing is that first the fact that a meeting has been held for a shorter notice, that shall be stated in the notice. We need to specify that why we have conducted this shorter notice meeting. Also, if we are holding a meeting at a shorter notice, then we need to and is deviating from the conventional practice, then this fact should be brought out that the notice convening the meeting as a good practice. Then the reason for convening the meeting at a shorter notice means we need to specify the reason that why it is being held at the shortest notice. Now, presence of independent directors or ratification of the decision. So if we talk about that ratification of the decision, that is, if no independent director are present at meeting held on the shorter notice or on the subsequent circulation of the minutes, one of the decision of any of the decision taken at such meeting is disapproved or not ratified by at least one independent directors, means that could be done after the subsequent circulation of the minutes, and if none of the directors and any of the decision taken in the meeting is disapproved, if nobody is disapproving or not ratifying by at least just a minute. Okay, we'll discuss later on. Thank you.